Now, the aviation firm Celebi has moved the Delhi High Court against the Indian government's move to revoke its security clearances. In the plea, Celebi Airport Services India has claimed the decision was based on a vague international security concerns, with no specific justifications given. The company has also said in the plea that the move threatens nearly 4,000 jobs and could hurt investor confidence. Celebi also argued that citing the national security without any explanation is legally unsustainable. And this move has come after the Indian government had revoked the security clearance of Celebi. The Bureau of the Civil Aviation Securities Order, the BCAS order, had come days after the Turkish President Erdogan openly backed support to Pakistan and condemned India's Operation Sindoor. Remember, the Turkish President Erdogan went a step ahead and supplied drones to Islamabad that were used to target the civilians across the Indian cities last week. And we have all seen the cost of retaliation that Pakistan had to pay. But despite that, in fact, the Turkish side continued to offer their support. Vipul Saxena, senior aviation expert, and Rudra Vikram Singh, who's a Supreme Court lawyer, joining me live on the telecast. Appreciate you both being present on the broadcast. Now, Mr. Saxena, first question to you, as in fact this very significant order by the BCAS has come and revoking the license and clearances to the Turkish firm Celebi, but Celebi continues to take it through the legal course. But when we talk about how exactly there has been a mass call boycotting the relations with the Turkish firms, this move in interest of the national security has also given a big setback to the operation handling setup at the airports. So how does India and Bharat at this point of time continues to grapple with that as a big change in the strategic partnership with Turkey has come forward?
Turkey was a friendly country to us. We had very good cultural relations and business relations and defense cooperation with Turkey for quite some time, quite long time. But of late, during this Indo-Pak war, with this recent conflict, Turkey has openly supported Pakistan. And second thing, in various attacks of drones, maximum drones have been found made of Turkey. So in that case, Government of India has taken a stand that any attack by Pakistan or those who are supporting Pakistan on terror, they will be treated equally. So that is the condition which Government of India has taken, Government of India has taken. Now till time Turkey was a friendly country, security clearance was given. But now that country also has made a repeated instances that we are with Pakistan. I think they themselves has put themselves into a situation where they cannot be anymore be a friendly country. So in that scenario, Government of India has a full right to take such decision in the interest of national security. And there is always a clause of force majeure in every agreement which allows such agreements or such contracts to be terminated.
Mr. Saxena, absolutely. As you are also understanding that the BCAS had revoked the security clearances at this point of time when Turkey continued to offer their support for the hostilities committed by Pakistan. But when we talk about the legal side of it, does the Turkish-based firm stand, in fact, true to its sense that they can approach and get any remedy under the legal route that they have now resorted to?
I don't think that they stand any chance of any legal remedy in India because their country themselves have declared repeatedly that they are with Pakistan. So in such situation, I don't think any judicial body or any judiciary will be able to stand by with their stand. And the reason that they're given is very, very flimsy. I mean, it's protection of job. That's Indian government's duty to provide job to their employees, their citizens. And apart from that, investors, we are not interested in investors' interest because investors are all located abroad. And if you see the shareholding pattern of Turkish Celebi, they say 65% are public investors which are located in Canada and all that. So those are all unknown entities. The 35% shareholding is with the Celebi family of Turkey. They are Turkey's big family. And definitely a big businessman of Turkey cannot be non-aligned with the political masters of the country. It cannot happen. So these are the reasons which are unspoken anywhere in the document, but definitely when it comes to intelligence or security clearances, those people definitely watch for it and they don't take chance on such grounds.
Well, absolutely, Mr. Saxena. Thank you very much for weighing in on this matter, and also now joining me live on the broadcast is, in fact, Mr. Rudra Vikram Singh, who's a Supreme Court lawyer. Mr. Singh, appreciate you joining me this morning. Now, how do you see the Turkish-based aviation firm approaching the Delhi High Court, challenging the centre's decision, as in fact centre has cited, while also revoking the licenses, that it is in the interest of national security? So how does one intend to defend this even in the courts, as the Turkish airport services, the Celebi, has cited that this claim is unsustainable?
See, when there is a dispute about national security, or when there is a concern about the national security, that has to be seen in supreme. Nothing is bigger than, nothing is supreme than our national security or of any country. So, Government of India, Union of India has taken a decision in the interest of their citizen, because if there is an issue related to interest of security, that has to be blocked. And let me remind you one judgment by Honorable Supreme Court, that is Kulja Industries Limited versus Western Telecom Project, wherein Honorable Supreme Court has held that a state has inherent power to blacklist, to revoke any contract, and that cannot be confronted by any statute if there is something related to national security. So, yes, anybody has the remedy to go before any court of law. They can directly approach to the Supreme Court. They can directly approach to the High Court. Obviously, there is a Indian Contract Act in 1872. They might have gone to Honorable High Court, stating that Indian Contract Act, because there will be a contract between Union of India and that company. So they might have gone quoting that contract, that there may be a clause that you cannot revoke this license arbitrarily. There has to be a principle of natural justice. So their claim would be like this, that there has to be the natural justice has to be seen. We have to be give opportunity to be heard. But the Union of India will put their point on this way only, that if there is a point of national security, we cannot compromise of anything.
Absolutely. In fact, Mr. Singh, thank you very much for being with us on the broadcast and also detailing it for our viewers as what this now controversy is going to look like.